Mic check. Mic check.
We'll see. HVAC guys get up every morning.
Mic check.
Because nobody calls and says, my heating doesn't work, my air conditioning doesn't work. But you get to me.
Mic check.
We'll see. HVAC guys get up every morning.
Mic check.
All right, let's go on the record. Good morning. Today is July 18th, 2024. The time is 9:03 a.m. The commission has set this time for an evidentiary hearing in the case captioned as Missouri Coalition for Fair Competition and Corey Malone Complainants versus Union Electric Company doing business as Ameren, Missouri Respondent. My name is Ken Sire, and I am the regulatory law judge presiding over this hearing. This hearing is taking place in the Public Service Commission hearing room, room 310 of the Governor Office Building in Jefferson City, Missouri. Let's have counsel for the parties make their entries of appearance, starting with counsel for the complainants.
Good morning, Judge and Commissioners. My name is David Barrett. I'm an attorney
All
from
right.
Jefferson City.
Mr. Barrett, I'm going to ask you to press the little button for the microphone and repeat what you just said.
It was pressed. I just wasn't close enough. I apologize, Judge. My name is David Barrett. I'm an attorney here in Jefferson City on behalf of the complainants.
All right. Then on behalf of the staff of the commission
My name is Carolyn Kerr on behalf of staff.
and on behalf of Ameren, Missouri.
Good morning, Judge. Jim Lowry on behalf of Ameren, Missouri.
All right, thank you. For those in the hearing room, I ask everyone to silence their cell phones, and as we kind of found out already, if you're here at the council tables, if you will press that button for the microphone where the green light lights up, that will help us greatly in being able to hear you and the court reporter being able to hear you. Mr. Lowry, you had filed a request to take official notice.
Yes, Your Honor.
Do the other parties have any objection to that request?
Complainants have no objection.
All right.
None.
All right, then I will take official notice of those, 21 documents listed in the request. And for the sake of reference, I'd like to number those as exhibit numbers 101 through 121, if that's all right.
Judge, I actually anticipated, I wasn't sure how you would want to handle it, but I actually have an exhibit list that lists them that way, if you would like to have it.
We are of the same mind, is that what
But
you're saying?
I wasn't sure, so I didn't file it that way.
Okay.
I think it goes through 122 if you count the pre-file testimony, but unless my paralegal got it wrong.
Mr. Lowry,
I'm
do you
sorry.
have copies of this for the other parties,
I don't, unfortunately. I can email it to them.
if you would?
Sure. Let me email those to them, Judge.
All right.
And Judge, if it makes it a little easier for you, we've agreed that complainants exhibits 1 through 9 will also be offered and received without objection, subject to hearsay objections, as well as staff's exhibit. That way all the pre-filed exhibits are in, just for simplicity's sake.
All right. Then,
And Judge, just for a point of clarification, I don't have an objection to the admission of the complainant's pre-filed testimony, subject to the hearsay objections that are reflected in our motion to strike that was filed, I think, on May 20th. So subject to those objections, I don't have an objection. And I will put Ms. Harmon on the stand when the time comes. She has a couple of minor corrections to her testimony, and I'll just move it in the normal manner at that time, if that's okay.
okay. Then the tribunal will take official notice of what is now marked as Exhibits 101 through 122. The Exhibit 100 is admitted. Exhibits 1 through 9 are admitted. And Exhibit 200 is admitted.
And just the complainant's exhibits you just admitted are subject to our objections, correct?
Correct.
Thank you.
Correct. All right, before we go any further, I'd like the commissioners to identify themselves for the record, starting with Chair Hahn.
Kayla Hahn, Chair of the Commission.
Oh, closer.
Commissioner Glenn Kochmeyer.
Commissioner Jason Holzman.
Commissioner John Mitchell.
All right, thank you, commissioners. As far as the order of the witness testimony today, we will begin, if Mr. Barrett, as Mr. Barrett informed me before we went on the record, we actually will take his witnesses out of the order that was previously filed. And so we will hear testimony from Mr. Sir and Mr. Keevan first, and then Mr. Malone for the Missouri Coalition for Fair Competition and Mr. Malone. And then the staff witness, Mark Kiesling, and Ameren, Missouri witness, Shelley Harmon. All right, are the parties prepared for opening statements?
Yes, sir.
All right, Mr. Barrett, you're free to give your opening statement. And you can use the podium if you like, or you can stay at your table.
I'll stay at the table just
Gotcha.
for convenience sake. Thank you, Judge. Good morning, Commissioners. My name is David Barrett. I stand here in the place of our colleague Terry Allen, who kept his promise to his wife to retire on his 80th birthday. Mr. Allen represented the Missouri Coalition for Fair Competition from its inception and in prior cases before this commission. The policy adopted by the legislature in the fair competition law that we're discussing here today is simple. Utilities can't fund their participation in the heating, ventilation, and air conditioning industry with regulated rates. The evidence will show that through contractors, Ameren has been doing so. Instead of directly participating, forbidden by statutes and previously prohibited in actions before this commission, Ameren is now trying to do an end run, hiding its participation in the industry under the guise of the commission's energy efficiency tariffs. But they could not resist the temptation, or over the decades they forgot that they can't. So they ran the advertising campaign under their name without the disclaimers required by law. They set up a computer site under their own name that recruits HVAC, heating, ventilation, air conditioning customers using rate-regulated funding, and again, without the disclaimers required by the Fair Competition Law. They utilized a single contractor of the hundreds in their service area, and not only provided advertising and sales leads to that contractor, and later a couple of other contractors in what we are calling a closed contractor pool, but made people look like Ameren employees by dressing them in Ameren shirts, providing Ameren ID cards, and the estimates themselves bearing Ameren's logos and other indicia. By doing so, they have violated the spirit and the letter of the Fair Competition Law. By doing so, consumers have been misled. Ratepayers have provided for the advertising and administrative expenses when people choose a program. They are losing out on fair competition and pay the price to Ameren and lose their utility service if they don't make the payments for these projects. We thank the Commission for its attention and look forward to the presentation of evidence.
Thank you, Mr. Barrett. Ms. Kerr, would you like to give an opening statement for the staff? Oh, I'm sorry. You are correct, Chair. Chair, do you have questions for the Mr. Barrett?
Good morning, Mr. Barrett.
Good morning, ma'am.
I'm assuming that if Ameren did engage with HVAC contractors, as you say they did, and it was only for the purpose of the pay-as-you-save or other energy efficiency programs, if they were only doing it in that way, explain to me the violation if there is an exception in the law.
I think what we are dealing with, Commissioner, and what I anticipate I will brief extensively, is the idea that when you have two laws, they are to be read together. They are to be read, the Latin term sometimes is pari materia, where following one law does not excuse you from violating another.
Thank you.
Are there any other questions from the commissioners? All right, hearing none, Ms. Kerr, would you like to give an opening statement?
Yes, thank you. May it please the Commission. My name is Carolyn Kerr, and I'm the attorney representing the Staff Counsel's Office of the Missouri Public Service Commission. This case came to the attention of the staff when Mr. Malone and the Missouri Coalition for Fair Competition, or the MCFFC, filed. I'm sorry. Siri's not listening. Let me start. This case came to the attention of the staff when Mr. Malone and the MCFFC filed a formal complaint with the PSC alleging that Ameren, Missouri, or Ameren, had violated what it referred to as the Fair Competition Law by engaging in HVAC services. The law that Mr. Malone and the MCFFC refers to is codified in sections 386.754 through 386.764 RSMO, and actually has no formal title, but may also be referred to by the parties as the HVAC law. This law forbids utilities like Ameren from allowing their affiliate contractors to use its name to engage in HVAC services in a manner which subsidizes the activities of the company. In doing so, Mr. Malone and MCFFC allege that Ameren is using the affiliated contractor companies, in this case Anton's Air Conditioning and Heating, through the Pay-As-You-Save or PAYS program and the Community Savers low-income programs within Ameren's MIA-approved programs to compete against his company, Air Comfort Service, and other small businesses, thereby taking an unfair advantage against them. They claim that Ameren, through these two MIA programs, is purposefully not allowing Mr. Malone's HVAC company to fairly compete for inclusion in those programs. Mr. Malone and MCFFC want the Commission to order the staff to audit Ameren's books and records and make a finding that Ameren violated the provisions of sections 386.754 through 386.764 RSMO, then refer the matter to the Attorney General's office to take civil action against Ameren for civil penalties. The problem with that is that the staff has already done an investigation and submitted its report. Staff witness Mark Kiesling is here to testify and answer the questions the parties and the Commission has relating to the staff report he submitted on April 12, 2023. Staff sent out data requests and asked questions and reviewed Ameren's records. It concluded that Ameren did not violate any statutes, rules, or regulations pertaining to those sections of the law or any of its filed and approved tariffs. There is no more for staff or the Commission to do. If Mr. Malone and the MCFFC have any further complaints, the PSC is not the forum. I'll be happy to answer any questions. Thank you.
Do the commissioners have any questions for Ms. Kerr?
I have one quick question. So if the PSC is not the appropriate forum for this issue, then what is? Is it the Attorney General or?
I'm sorry, who? Is that Commissioner Mitchell?
Commissioner Mitchell.
Oh, okay. Does he need to repeat the question?
Yes,
Okay.
please.
Then my question was, if the PSC is not the appropriate forum to address this question, what is the appropriate forum?
Well, I believe the AG's office might be. The AG's office is the office that
That would be the,
I think so.
okay, thank you.
Or
Alright.
the civil, or the civil court.
Okay, thank you. Nothing further.
Okay. All right. Then, Mr. Lowry, would you like to give an opening statement on behalf of Ameren, Missouri?
I would, and I said enough, so I'm going to go ahead and stand up. Good morning, may it please the commission. Mr. Barrett described a statute that I think the coalition would like to exist, but that actually doesn't exist. To Chair Hahn's question, the commission approved and regulated energy efficiency programs that issue here are completely exempt from this law. And while I don't want to get into briefing or getting in too far in the legal argument, since Mr. Barrett mentioned it, the provision that says that is in the law in question. We're not talking about reconciling two different laws here. We're talking about reconciling one law, and we're talking about applying the provisions of the law that they say we have violated when that law itself says that we can't violate it through our energy efficiency programs because you regulate them and you approve them. So just to clear up that point. At the end of the day, while complainants have made a great many allegations about their viewpoint about this statute and about our behavior, what the evidence will show they haven't done and that they can't do is establish that we've actually violated the statute, either as a matter of law or as a matter of fact. Now, before I get into some of those reasons, I want to make sure in level set that we know what programs we're talking about and what they are. There are two programs that have been raised in this case. There's three, but one of them, there's no allegation about a violation. They are the Pays As You Save program, which was approved by this commission in 2020 and started in 2021. And there is the low income eligible program that the commission approved as part of the MIA 3 cycle, and I believe it became effective in 2019. It is otherwise known as the Community Savers Single Family Program. They are both targeted at low-income customers. The PAYS program, as I think you know, essentially provides financing at a commission-approved interest rate for not just HVAC systems, but other energy efficiency upgrades made to the home to help customers save money. The idea being that the low-income folks to which it's targeted probably couldn't afford to come up with the cash up front themselves. And the Community Savers Single Family Program actually pays for the measures that are installed instead of the homeowners paying them at all. And it's only available to certain income-limited, low-income customers. There are differences. The other program that they brought up is the HVAC program. That's the rebate program. The rebate program is much larger. It's been around, I think, since the first MIA programs were adopted, and there are distinctions in both its scope and size and its operation that lead to different approaches by the program implementers to the contractor networks. And I encourage you to ask Ms. Harmon more about this when she takes the witness stand, because the differences in those programs, which incidentally the coalition's members and Mr. Malone's company do participate in the HVAC program. The differences in those programs are key to why the contractor network for the low-income programs is much smaller and restricted as compared to the contractor network for the HVAC program. I would also note that the evidence will show that as we sit at hearing today, I don't believe the PAYS program is really an issue in this case anymore anyway, in terms of that program. The evidence will show that the complainants could participate as contractors in that program if they chose to do so, if they chose to agree to the participation terms, one of which is primarily that they have to provide their pricing, because the low-income customers who will actually pay for the improvements to their home, they have the ability to choose the contractor within the network that they want. But one of the criteria that they use to do that is price. So if they want to use a different contractor, they need to know what that price is going to be, as opposed to defaulting to just the lowest cost contractor for a given set of improvements. So back to why the complaint must fail. First and foremost, even if every word spoken by the complainants in their complaint and in their pre-filed testimony was true, as I mentioned, these programs are exempt from the statute. That's really, I could probably sit down now and I wouldn't need to say anything else. But second, but I will say just a few more things. Second, as staff has indicated, what the coalition wants you to do is adjudge the company guilty of a civil violation that only a circuit judge who finds him or herself that there is a civil violation could adjudge and impose penalties that only that circuit judge could impose, and only if the Attorney General refers the matter to the courts. So that's a second legal infirmity. I will brief this in our case, but there's a third legal infirmity that hasn't been brought up yet, and that is Section 386, 510, I think it is. I may have the citation wrong, but as you may know, there is a specific provision in the Public Service Commission law that, it's actually 386, 550. Sorry, I remembered it as I was standing here. There's a specific provision in the Public Service Commission law that prohibits a collateral attack on the Commission's orders and their tariffs. And those tariffs, by the way, have the force and effect of law, as I think you know. And I would submit that this entire case is a collateral attack on your orders and the tariffs you've approved implementing the programs at issue. So that's another legal problem with the case. Now, setting aside those legal infirmities, complainants' claims fail on the evidence anyway. Their first claim, which is reflected in complaint paragraph 7, is that Ameren, Missouri is engaged in HVAC services. I'm going to take Ms. Kerr's lead and quit trying to say HVAC. That's simply not true, and the evidence doesn't establish that it's true. In order to engage in HVAC services, Ameren, Missouri has to sell or warrant or install or maintain, and I won't go through the whole list, but there's a specific list in the statute that defines what that is. There's no evidence that we have done or do any of those things. The second claim in paragraph 8 of the complaint is they allege that contractors, who by the way are not selected by Ameren, Missouri, and with whom Ameren, Missouri has no contract, they claim that contractors are using our vehicles and service tools, et cetera, to engage in those services. Well, first of all, there's no evidence that that's happening. And second of all, there's a specific definition of utility contractor in the statute that they rely upon. There's a specific definition of affiliate in the statute that they rely upon. And there's absolutely no evidence that these folks qualify as utility contractors within the meaning of the statute. We don't have a contract with them, therefore they can't be utility contractors, and we don't own or control them, and so they can't be affiliates. So their claim fails, that claim also fails. Their third complaint, complaint paragraph 9, is that we are not providing a disclaimer that they say we have to provide. Well, first of all, the other exemptions and the fact that we're not providing the HVAC services and we're not assisting a utility contractor and affiliate makes that claim moot. But the claim also doesn't make any sense, because what the disclaimer, when it's required, and it's not required here, but what the disclaimer must say, if it is required, is that these services are not regulated by the Public Service Commission. Well, these services are regulated by the Public Service Commission because they're being delivered pursuant to a regulated and approved program. So it doesn't make any sense you would give a disclaimer that says something that's not true. Their next claim, paragraph 10, I guess I've really already covered that. That's the whole utility contractor and affiliate claim, which is simply fails both on the facts and the law. And then their last claim, which is in paragraph 11, says we violated your HVAC law regulation. Well, the statute in question says that your regulation cannot enlarge, add to any requirement of the statute. Well, since we don't violate the statute, we can't violate your regulation. So that claim also fails. At the end of the day, the complainants don't like the way the program implementers who choose these contractors in community saver single family, they don't like the way they've set up the contractor network. They don't like the fact that it's a narrow network, and they want a piece of the pie, so to speak. They want a piece of the energy efficiency dollars that are being paid to put systems and other improvements like insulation, et cetera, in these customers' homes. But the HVAC law doesn't prohibit that. In fact, the HVAC law recognizes that if you approve a program and you approve a tariff, and we're delivering programs pursuant to that, then we're not within the HVAC law to begin with. So with that, I appreciate your attention this morning, and if you have any questions for me at this time, I will try to answer them.
All right. Excuse me, do the commissioners have questions for Mr. Lowry? All right.
Thank you very much.
Before you leave, Mr. Lowry.
Yes, sir.
I do have a question for you. In your request to take official notice of several documents, many of those documents had to do with a previous case that Mr. Malone and the Missouri Coalition for Fair Competition brought against Ameren, and it's our case number EC 1999-0327. From Ameren's perspective, are there similarities between that case and this case?
No, there aren't, for at least two reasons. First of all, that was a non-tariff, non-approved program. It's just a program that Ameren, Missouri offered on its bill. So it had nothing to do with energy efficiency. In fact, it had nothing to do with any commission-approved or regulated program. Secondly, Ameren, Missouri was in fact engaged in the activities that happened in that program. It's not a situation where Ameren, Missouri had a contract with a program administrator who then separately hired an administrator, and then that implementer then hired contractors. Ameren, Missouri was engaged in the appliance repair. And so, and what Ameren, Missouri admitted to it, and the case was resolved by stipulation, the program was not regulated by the commission, and we didn't give the disclaimer. I mean, there's just no real question about that. So we agreed very quickly. We stopped very quickly. We agreed. We stipulated the case out quickly, and you approved the stipulation. The case was over.
Question. Mr. Lowry, when the home assessments are done for the PAYS program, are there multiple contractors that are listed that the homeowner could use to install the HVAC or install whatever energy efficiency upgrades they're having done, or is there only one?
I believe there are 5 or 6 at this time.
Okay.
And just to clarify, E-Utility, which is the program implementer with whom we don't have a contract, but our administrator does, he actually does the assessments. But I think there are either 5 or 6 at this time.
Okay, so when E-Utility does the assessment, they're the ones that identify the homes that might be eligible. They're the ones that identify which contractors might be eligible to do the work.
That's right. They select, they have requirements to be a participating contractor, and actually, if the contractor meets those requirements, any contractor can be available. But so far, there's only 5 or 6 who have expressed that willingness to do that.
And E-Utility sets those contractual terms?
Yes, E-Utility sets those contractual terms with those contractors.
Thank you.
It's double E-Tility. So think of utility, except get rid of the U and put EE at the beginning. I have a hard time saying it, to be perfectly honest.
All right. Any further questions from the commissioners? All right. Thank you, Mr. Lowry.
Thank you.
Mr. Barrett, I will ask you the same question that I asked Mr. Lowry as far as the 1999 case. Are there from your perspective, are there similarities between the two cases?
He described it accurately. It's just that we've butted heads over this law before, and that's why it came up.
Okay.
I do not propose that the situations were similar.
Okay. One thing that I meant to mention at the top and neglected to was the commission does have an agenda meeting scheduled today for noon, so we will have to break around that meeting, so possibly break 11:30, 11:45, and reconvene 1 o'clock or later. So. All right. All right, then we are at a point where we will take testimony from the witnesses. So, Mr. Barrett, call your first witness.
I would like to call Mr. Keevan first, if he's on the phone.
I am.
All right. Can you give me a second, Mr. Keevan?
Sure.
All right, Mr. Keevan, before you testify, I'd like to place you under oath.
Sure.
Do you swear or affirm that the testimony given in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right. Mr. Barrett, go ahead.
Thank you. Mr. Keevan, this is Dave Barrett. Did you prepare written testimony in advance of your appearance here today?
Yes, I did.
And it bears your signature?
Yes, it does.
And in fact, it was signed before a notary public?
Yes, it was.
All right. And are there any changes that you would make in your testimony here today?
No.
And certain parts of your testimony, you tell the commission about things that you heard from other people. You don't know if what those other people told you specifically was true or not, do you?
No, sir.
You just took their word for it and made your own investigations and engaged in the conduct that's described in your testimony based on what they said, whether it was true or not. Is that right?
Yes.
I have no other, I would strike that. I have no other questions of the witness.
All right, thank you. Ms. Kerr, do you have questions for the witness?
No.
Mr. Lowry?
No questions, Judge.
All right, Mr. Keevan, thank you for your testimony.
Thank you.
And Mr. Keevan can hang up now, can he not, Judge Sayre?
Yes.
Thanks, Mike.
All right.
Thank you.
Call your next witness.
Dave, sir?
And, Mr. Sir is testifying via WebEx as well.
Are you there, Dave? And have you unmuted yourself, Dave? I can see.
Can you hear me?
There you are. Well,
Mr. Sir.
yes.
Mr. Sir, it's Judge Sire. I will swear you in before you testify. Do you swear or affirm that the testimony given in this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, thank you. Go ahead, Mr. Barrett.
Sir, would you please state your name for the record?
David Lee, sir.
And Mr. Sir, did you pre-file testimony in regards to today?
Yes.
And did you sign that testimony?
Yes, sir.
Did you sign it under oath before a notary public?
Yes.
And is the testimony that you would offer here today, if you were to go through all those questions and answers, would it be the same?
Yes, sir.
And there are parts of your testimony where you mention things that you heard from other people. You don't know if those things specifically are true or not, do you?
I do not.
But based on what they told you, you took certain actions and those are reflected in your testimony?
That is correct.
All right. I have no other questions of the witness. Thank you, Judge.
Ms. Kerr, any questions?
No.
Mr. Lowry?
No questions, Judge.
And any questions from the commissioners?
Yes. Mr. Sir, Chair Hahn, just to clarify in your testimony, you allege, or you say that you were just unaware of the orientation meetings for the pay-as-you-save contractors, and that you believe that the program is administered unfairly. Are you aware of the option to participate in the pay-as-you-save program as a contractor if you meet the terms that are set by e-utility?
I was not. I was not informed of it. I heard it from others. I was not invited into it or seen any documentation or.
But nothing would prohibit you from becoming a contractor, is that right?
That's right.
Okay.
No.
Thank you so much.
Is there any recross from the other parties?
No,
None.
Judge.
Okay. Any redirect, Mr. Barrett?
No, thank you, sir. May Mr. Sir be excused?
Yes.
You're done, Dave. Thank you.
Thank you, man.
All right, Mr. Barrett, call your next witness.
Corey Malone. Judge, and Mr. Malone is here with us.
Mr. Malone, if you can take, if you can take the witness stand there, please. Thank you. Would you raise your right hand, please? Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Go ahead, Mr. Barrett.
Thank you, Judge. Mr. Malone, would you please state your name for the record?
Corey Ryan Malone.
And Mr. Malone, did you pre-file testimony for today?
I did not.
Did you sign the document that we've marked as Exhibit 1?
Yes,
Where
yes.
you answered in writing certain questions?
I did, yes.
And in fact, we had attached exhibits to that. There were some pictures, some documents, and so forth. Is that right?
Correct.
And you signed that under oath
I did.
before a notary public?
I did.
At some inconvenience, as I recall.
Yes, it was.
All
Yes.
right. And after reading the pre-filed testimony of Ms. Harmon, you also filed reply testimony. Is that right?
Correct.
And that was also under oath, signed before a notary public?
Correct.
Would your, if we went through the questions and answers, would your answers to the questions be the same today as they were when this testimony was pre-filed?
Yes.
And, well, essentially, your deposition's been taken, and Mr. Lowry made some fine points that I'm sure he'll discuss with you, but essentially, your position in this hasn't changed, has it?
No, and Mr. Lowry brought some points up that we discussed.
All right. And I have no other questions of the witness, Judge.
All right. Ms. Kerr, do you have any questions for the witness?
No. Thank you.
All right, Mr. Lowry, any questions?
I have probably just a very few. Good morning, Mr. Malone.
Good morning.
Mr. Barrett asked you whether your position has changed, and I just really have one, maybe two areas of inquiry. First of all, your Exhibit 3 was actually attached by mistake, and Exhibit 5 is what you sort of intended to be Exhibit 3 in terms of the text around the description of Exhibit 3. Isn't that right?
Correct. That's one of the things we came up with in the deposition.
Okay, just so the record's clear. And then the second thing is, while you may contend that this case was needed to make sure that the PAYS contractor network was opened up, the fact is, putting aside whether that was true or not, the fact is, as it stands today, you're no longer contending that the PAYS program violates the HVAC law, right?
Correct.
Because as you sit here today, you and your members, if they agree to the terms for participation, could be a contractor in the PAYS program, right?
Yes, sir.
That's all I have, Judge. Thank you.
All right, thank you. Chair Hahn, do you have questions? Any other questions from, or any questions from the other commissioners? All right, Mr. Malone, I've got a question or two. I touched on it with Mr. Barrett and Mr. Lowry, but the 1999 case, what you allege that Ameren has done here recently, how is that similar to that previous case?
Judge, this case is a little different in the fact that Ameren was actually in the program, and I believe it was home appliances back in 1999. The biggest difference between what we filed a few years ago and that program was the Community Savers Program started in 2019, and that program is still closed. As far as conversation to try to even find out, my members came to me as the coalition president back around 2019 and asked how they can participate in this program. And we were just stonewalled and not given any information, and still haven't to this day. When the PAYS program came out, that was a closed program, to my knowledge, until this action was filed. Once this action was filed, the PAYS program was open to contractors when we had our meeting in 2023.
And who is the administrator of the Community Savers Program?
That is, I can never remember their name, Resource. It's in my notes, if I can grab my notes. May I?
Sure.
Resource Innovations.
All right, thank you. From your perspective, how do you believe Ameren has violated this fair competition law, the HVAC law?
Our council has requested information on how the third-party administrators, which would be Community Savers, which would be Resource Innovations, and PAYS, which would be e-utility, and I have a hard time saying that as well. We asked what the requirements were on selecting those third-party administrators, and to my knowledge, I think the terms were it was irrelevant. So we don't know what the relationship is between the third-party administrators and Ameren, and all we ask is just an opportunity to be able to serve our community and serve our customers. The biggest issue that my members have is the Community Savers Program is for low-income housing. And it is a program that, from what I understand, the candidates, the homeowners or the renters, whatever the case may be, don't pay for the program. It's basically a way to go in and update their homes to make them more energy efficient, to lower the utility bills. But if the homeowner doesn't pay for it, then that means all the ratepayers pay for it, which includes all of us. And with no competition, how are we to ensure that they are getting the best price for their repairs?
Okay. Ms. Kerr, do you have any follow-up questions?
No, thank you.
Mr. Lowry, any follow-up?
I may have just a few, Judge. And I have an exhibit I need to mark.
I apologize, I don't think I have enough for everybody to get, Judge.
You can certainly have mine back. This is the same as my exhibit 5.
At least have 2 out of 3. I believe it'd be 123, is that right, Judge?
That's correct.
I have an extra if you want one for, yeah.
Sorry about that.
Yes, you did. Sticker. Oh, I need to give it to the witness.
I have a copy of this already marked.
That's fine.
Thank you.
Mr. Malone, you've been handed what's been marked for identification. In this case, is Exhibit 123. It's also Exhibit C from your deposition. Do you recognize that?
Yes.
And in response to the judge's questions, you indicated that you had asked, your attorney had asked for information about, I believe you suggested or said about the PAYS program and about the Community Saver Single Family Program. Do you recall that?
Yes.
Isn't it true, as shown on Exhibit 123, that the questions posed to the company were only about the PAYS program?
It appears to be.
So when the company didn't provide the information that, first of all, you didn't ask for the information that the company objected to as irrelevant. You only asked for the PAYS information. You didn't actually ask for the Community Savers information. Isn't that right?
It asked for the RFP for e-utility.
And e-utility is involved with the PAYS program, not with the Community Savers program, isn't that right?
Correct.
Judge, with that, those are the only questions I have. Thank you.
Are you asking Exhibit 1 for Exhibit 123 to be admitted?
No.
Okay. All right. Ms. Kerr, any follow-up questions?
None.
All right. Mr. Barrett, do you have any redirect?
I have none, but just so it's easier for you, when you look at the record later, Judge Sayre, that exhibit is also my Exhibit 5.
Exhibit 5.
So it's in the record if you want to actually
Okay.
look at it.
I
Gotcha.
forgot about that. Thank you.
May Mr. Malone return to his seat in the gallery.
Not at this time. Chair Hahn?
My apologies.
Hi, Mr. Malone, after reviewing this Exhibit 5, did you do a similar request for the third-party vendor over the Community Savers program?
Not to my knowledge.
Okay,
And the answer is no, if I might interject, Chairman.
thank you.
All right. Now, Mr. Malone, you may step down.
Thank you.
Mr. Barrett, do you have further witnesses to call?
The complainant's trust.
All right. Ms. Kerr, you may call your first witness.
I'll call Mark Kiesling.
All right, Mr. Kiesling, you have your right hand raised. Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead, Ms. Kerr.
Morning.
Good morning.
Could you please state your name and spell it for the record?
It's Mark Kiesling, Kiesling.
And by whom are you employed and what's your position?
Missouri Public Service Commission. I'm a senior data research analyst.
And have you prepared and filed testimony in this proceeding? Specifically, your rebuttal testimony on June 5th, 2024, which has been marked as Exhibit 200?
Yes.
And did you have an opportunity to prepare a staff report in this case, which is included as Schedule MK-R2 and which is attached to Exhibit 200 to your rebuttal testimony?
Yes.
And is the information you prepared and filed in this case that's contained in those two documents true and accurate to the best of your knowledge?
Yes.
Do you have any changes or additions to make to any of those documents today?
No.
And those, Exhibit 200, I guess, has been already admitted into evidence.
That's correct.
I tender the witness for,
All right. Mr. Lowry, any questions?
Just a few, Your Honor. Good morning, Mr. Kiesling.
Good morning.
Mr. Kiesling, after conducting the investigation that the staff conducted and ultimately concluded that Ameren, Missouri was not taking activities in violation of the HVAC law, I just want to clear up a couple things. E-Tility, not Ameren, Missouri, does the PAYS assessments, right?
Correct.
And Resource Innovations has contractors in their contractor network that do the assessments for the Community Savers Single Family Program, not Ameren, Missouri, right?
Correct.
Staff didn't uncover any evidence that Ameren, Missouri was selling or installing or maintaining or repairing or doing any other activities that are listed in the definition of HVA services in connection with these two programs, did it?
No.
In fact, staff didn't uncover any evidence that E-Tility or Resource Innovations was engaged in any of those activities, did it?
No.
And in fact, according to staff's investigation, it's E-Tility that chooses the contractors for PAYS, and it's Resource Innovations that chooses them for Community Saver Single Family, right?
Yes.
There's no contractual relationship between Ameren, Missouri and any of those entities, isn't that right?
Yes.
Thank you.
All right, Mr. Barrett, do you have cross?
I do, thank you. Mr. Kiesling, my name is David Barrett. It's a pleasure to make your acquaintance. I know the Judge Sayer, no doubt, and the commissioners know you well. I don't, so if you'd indulge me with a couple of questions. Could you tell us what background you have in investigating these types of issues?
As far as the complaint,
Yes.
I've been at the commission for close to 10 years. I've worked several complaint cases.
And I looked at the list of prior cases that was attached to your testimony. Can you tell me which ones of those involved questions of statutory violations like this?
Almost all complaints that come to the commission usually involve statutory issues, potentially, or rule violations.
All right. And which ones specifically?
It just depends on the complaint.
And based on staff's investigation, is there any question that utility and resource innovation are at least contractors with Ameren?
Can you repeat that again? Sorry.
Based on your investigation, is there any question that utility and resource innovation are at least contractors with Ameren?
Objection assumes facts not in evidence, unless he's asking a hypothetical that if they were contractors. But there's no evidence that they are.
I'll sustain the objection.
Hypothetically, did you learn whether or not, did you make any inquiry into whether e-utility and resource innovations were contractors with Ameren?
No.
Did you make any inquiry into whether they were affiliates as defined by the statute?
Yes.
And what did you discover?
They were not contractors. Or affiliates, I'm sorry.
Were they contractors?
They're implementers of programs through the Ameren's MIA program.
All right. And how did they, what was their relationship with the company? How was that established? Just friends in the same building, or
No.
did they have some sort of agreement with Ameren to provide these services?
Ameren has approved MIA programs, and Ameren finds third-party implementers to implement those programs.
All right. And did they have some sort of contract with Ameren to fulfill those obligations? If you know.
I don't know that off the top of my head.
If you were to refer to your investigation, would you be able to answer the question?
Possibly, yes.
All right. If you would, please.
I have it here.
I'm sorry?
Well, is there a particular thing you'd like me to look for?
Well, I didn't see it in there, and that's why I'm asking you to help me. If I missed it, Judge Sayer needs to know about it. Is there anything in there about the relationship, the formal relationship between e-utility or Resource Innovations and Ameren?
I'd have to take a minute to go through my report
Certainly.
and refresh my memory.
It's a little bit unfair, I understand.
There's a section here that we say that e-utility serves as the implementation contractor for the PACE program.
All right. Implies there's a contract, at the very least, is that right?
Potentially, I don't know that off.
You never saw the contract.
Correct.
And in regards to Resource Innovation, there's nothing in there at all about their relationship with Ameren, is that right?
Correct.
And is there any question that these program costs are recoverable in regulated rates?
They're not in rates.
Where are we going with this?
In fact, the customers pay back the costs of this program through rate M1. Don't the tariffs refer to rate M1 and payback and their responsibility to pay back the costs of the program?
The program is not in rates.
All right. And in fact, Ameren has an approved 3% overhead charge for all of the costs that it incurs that are passed on to these low-income customers, is there not?
Objection.
recall?
Relevance, where we, I'm not exactly sure where we're going with this line of questioning and
Well, I'm not sure what the objection is.
relevance.
As to the relevance, the statute requires that I show that Ameren is using regulated rates to pay for this conduct that we allege is improper, and that's why I'm asking the rate questions.
I'm going to overrule the objection, but let's get to the point here.
Yes, sir. Do you recall the question, sir?
No.
Judge Sayer, could we have it read back?
Ms. Bench, if you don't mind.
And in fact, Ameren has an approved 3% overhead charge for all of the costs that it incurs that are passed on to these low-income customers, or not, or do you recall?
I don't recall. I'm not aware of what you're talking about.
Have you ever seen Complainants Exhibit 9, and may I approach the witness to tender the exhibit?
You may, yeah.
I'm not asking for memory, I'm actually going to try to be helpful. Have you had a chance to look at the exhibit, sir?
I've flipped through it, yes.
Have you ever seen it before today?
No.
Haven't had a chance to see if it has any of the disclaimers that we suggest are required by the statute?
I'm not familiar which disclaimers you're referring to.
Very good. If I can approach the witness again, Judge?
You may.
Sir, I'm going to trade you, I'm going to hand you what has been marked Exhibit 5, and I will take back Exhibit 9. Would you agree that the questions asked in 1.4 and 1.5 are relevant to determining the issue of the affiliation, using the term colloquially, the relationship between Ameren and its contractors?
I'm going to object to the extent it's asking this witness to make a legal determination about what is and isn't relevant.
He was, if I might suggest, he was the investigator, and so he probably has some idea of what I'm talking about. I'm not asking for a legal conclusion, I'm asking it in the scope of his investigation.
I'll overrule the objection.
What was your question again? I'm sorry.
Could we have it read back, Commissioner? I'm sorry, Judge.
Ms. Bench?
I'm going to hand you what has been marked Exhibit 5, and I will take back Exhibit 9. Would you agree that the questions asked in 1.4 and 1.5 are relevant to determining the issue of the affiliation, using the term colloquially, the relationship between Ameren and its customers?
I cannot make that determination based on 1.4 and 1.5 on this paper.
And I didn't mean Ameren and its customers, I meant Ameren and E-Utility and Resource Innovations. Does that change your answer?
No.
Thank you. Finally, I notice, and just for convenience sake, page 6 of your memorandum. I believe it says something to the effect of, staff is unaware of any statute or commission rule that outlines or provides guidelines on how Ameren is to pick preferred contractors. Did I read that essentially accurately? And it's page 6 near the top. Take your time, please. It's the last line of the second paragraph.
Yes, you read it accurately.
Could Ameren, in fact, pick its contractors in a way that does not violate the fair competition law?
I'm not a legal analyst.
Objection.
Okay. It's a fair answer. I'm sorry.
I'll sustain the objection, though. You don't have to answer the question.
The conclusion of your report was that staff was not provided sufficient documentation to find a violation. What efforts did staff make to find that information?
We sent numerous data requests to not only the complainants, but also Ameren.
All right. And you were aware of the allegation that Ameren had provided Ameren shirts and ID badges to the contractors?
Yes.
And have you subsequently become aware of the photographs of people wearing Ameren shirts at the Anton's company picture?
We were provided a response with a picture, but it's blurry, it's hard to see.
All right. And you specifically noted that in your report that Ameren had not been reimbursed for its website costs by Anton's, is that right?
Can you repeat that?
Do you recall noting in your report that Ameren had not been reimbursed for the costs of operating its pay-as-you-save website by Anton's?
Can you point to where that is in our staff report, please?
Probably not. Let me put it this way. At the very least, you don't remember addressing that issue?
I don't recall addressing that. That's why I asked for you to.
Mr. Barrett, what was your question?
It was in regards to reimbursement for website costs?
Judge, I have copies of of his testimony and the staff report. If I could hand those out if you want me to.
I mean, they're actually in evidence already, Judge,
Right.
so.
Right, they're in evidence, but can you point us,
I can look.
can you point us to that alleged portion of the memorandum?
Let me look.
Now, there is a portion on page 5, about 2/3 of the way down, where it says, staff sent Ameren DRs asking if Ameren provides program-approved contractors with Ameren shirts, signing, advertising material, and other company materials. Ameren responded that they do not provide any company material to program-approved contractors. I don't know, Mr. Barrett, if that's what you're referring to, and if that includes the website photograph.
It addresses the issue more specifically, Mr. Kiesling. Do you recall in the, and I thought I had it printed here and I seem to have mislaid it, but do you recall in the staff document request 8.1, asking if, in paragraph 7, asking if Ameren, Missouri bills program-approved contractors for website administrative costs.
What are you referring to? I'm sorry.
Your document, the staff document request to Ameren, 8.1,
A data request?
yes.
What number is that? And again, I'm sorry.
8.1. Paragraph 7 specifically.
I don't have an 8.1.
And do you know if Ameren received reimbursement for its website reimbursement administrative costs?
Objection again to the extent it states fact and evidence, and misstates facts that are not in evidence. I think his prior questions was asking about Anton's, and whether there's reimbursement by Anton's. There's no evidence that Anton's, either in this data request response or otherwise, that Anton's has anything to do with the website. So I just want, so the extent the question assumes that Anton's incurred cost, or Ameren Missouri incurred cost relating to Anton's website or something, I object to that, is assuming facts not in evidence.
Yeah, I think the spin is a little different. The question is the Ameren website. I certainly am not intending to make any inquiry about an Anton's website.
Okay. You
Yeah.
you can answer the question as far as Ameren's website.
I'm not aware of the data request you're mentioning, and we never looked into any kind of website reimbursement at all.
And are you familiar with Ms. Harmon's testimony in this case, pre-filed testimony?
Yes.
And there was apparently some confusion about how the shirts were being used, whether they should have been co-branded or some such.
I'm not going to speak on behalf of Ms. Harmon's testimony. That's hers.
It had no impact on your opinions in this case?
We sent data requests requesting that information.
All right. No other questions of the witness. Thank you,
All right,
Judge.
thank you. Any questions from the commissioners? Chair Hahn.
Not a question, but Mr. Kiesling, just appreciate your work to do with the investigation. Seemed very thorough. Appreciate the report. I think it was very informative for us, so thank you so much.
Thank you.
All right, any questions from the other commissioners?
None from me, Judge.
All right, Mr. Lowry, do you have recross?
Well, I think since the bench didn't ask any questions, I don't think I get a chance to recross, do I, Judge?
All right, fair enough.
I would like to, but I don't think I'm supposed to.
Fair. All right. Then, Mr. Kiesling, I believe you're through. Thank you for your testimony. All right, let's go ahead and take a break and reconvene at 10:25. All right, going back on the record. All right. Ms. Kerr, correct me if I'm wrong, but you don't have any further witnesses to call?
I don't.
Okay. Then, Mr. Lowry, call your first witness.
I'll call our first and only witness, Shelley Harmon.
All right, Ms. Harmon, you have your right hand raised. Thank you. Do you swear or affirm that the testimony that you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you.
Good morning, Ms. Harmon.
Good morning.
This is your first time at the commission, correct?
Yes, yes it is.
Did you cause to be prepared for filing in this docket rebuttal testimony that's been marked for identification as Exhibit 100?
Yes.
If I were to pose the questions in that test, well, first of all, let me back up. Do you have any corrections to that testimony?
Yes, I do.
Could you please state for the record by page and line number what those corrections are?
Yes. Page number 3, line number 7. File number, I need to add EO dash in front of 2018 to 0211.
Okay.
The second correction is page 5, line 9. I need to change program implementers to program administrators. And then on that same page, on line 13, I need to change program administrator to program implementer. And on page 9, line 6, I need to add an S to customer.
To make customer plural.
That's correct.
Are those the only changes you have to your testimony?
Yes.
With those changes, if I ask you the questions in that testimony, would your answers be the same here today?
Yes.
And would they be true and correct to the best of your knowledge?
Yes.
With that, Your Honor, I move for the admission of Exhibit 100 and tender Miss Harmon for cross-examination.
I believe at the start of the hearing, I admitted Exhibit 100, but I
Okay.
will
Thank you.
ask Ms. Kerr if she has any questions for the witness.
I do not.
All right. Mr. Barrett?
In your testimony, ma'am, you referred to co-branding issues. In your testimony, ma'am, you referred to co-branding issues. Could you tell us what that was about, what led to that discussion?
What part of my testimony are you referring to?
In your testimony, you were asked the question on page 15, line 10. Does Ameren, Missouri provide Ameren shirts for HVAC participating contractors? Tell me when you get there.
I'm here.
Okay. Have you had a chance to look at it?
Yes.
Okay. What was the genesis of that comment? What made you testify about that?
There was questions around the Ameren shirts and co-branding. So
Let me take you back for a
Sure.
second, just to make sure we're all on the same page. In what we call the Kulker estimate, Kuelker, there was a reference to a representative will come out, they'll have on an Ameren shirt and an Ameren ID card, and they'll be driving an Anton's truck. Isn't that right? Something to
I'm-
that effect?
I don't recall that.
Okay. But for whatever reason, you decided you wanted to tell us about Ameren shirts. Okay. And why, can you tell us why you addressed that?
Because there was some questions around the Ameren shirts.
Well, I guess that's my question. What were the questions as you recall them?
I don't recall what the questions were.
Just something that needed to be addressed?
I think it needed to be something that was called out.
All right.
There were allegations around the shirts.
And specifically, you saw a picture of a bunch of guys standing in front of a sign that said Anton's, and a bunch of them were wearing shirts that said Anton's, and then there's a picture of, I think it was 3 people standing there wearing what looks like black shirts with an Ameren emblem on the breast. Isn't that true?
I did see that picture, but it was unclear whether those were Ameren shirts.
Okay.
I did, however, reach out to the implementation contractor and verify that they do wear Ameren branded shirts. But the most important part of the contractors going into customer homes is that they wear a contractor badge. So when they wear a contractor badge, there have been cases, from what I understand, where they were wearing Ameren shirts. And the reason why that's important is that these these contractors are going into customers' homes. So for consumer protection and safety reasons, it's important that they know that they're working on behalf of the program.
And why is that?
It's an important part of implementing the program.
Why so?
So, because customers, particularly in the single-family income eligible program, they're apprehensive because we're giving away free stuff. So when they tie the program to something that's approved by the commission, they have trust that it's a legitimate program.
Well, they're not wearing commission shirts, are they?
No, they
They're
are
wearing Ameren shirts.
Yes.
And in fact, they weren't co-branded shirts, were they?
They were not co-branded, but these contractors were wearing contractor badges. In fact, the implementation contractor requires that they wear them
In fact,
because it goes hand in hand.
When we look at the Colker estimate, though, it says the people will have Ameren shirts and Ameren ID badges. It doesn't say they'll have contractor ID badges, does it?
I would have to look at it again and refresh my memory on that.
It's an evidence. We can deal with it later.
Okay.
But why would it be important to know the person is from Ameren as opposed to air quality or any other contractor? Isn't the contractor who they have to trust?
I'll talk about the programs a little bit, the Community Savers Program. So these customers are signing up for an Ameren program. Again, a program that is tied to a commission-approved program. So it's important that very first, when they go into the customer homes, that they know it's an Ameren contractor. There's scams out there all the time. So it creates trust with that customer. That's been a challenge with this program in the beginning. And this, again, it creates trust that this is a commission-approved program and that these are contractors that are working on behalf of the program.
And there have been scamsters before that impersonate Ameren employees, have there not?
I believe so, but not pertaining to this program.
Sure, but we're talking in general the importance of the Ameren shirt. It's not like getting a hold of an Ameren shirt is particularly difficult, is it?
I don't think it would be that difficult, but I don't know.
Okay. If I could have just a second, Judge. Judge, I thank the witness for her time, and I have no other questions for her.
All right. Do the commissioners have any questions for the witness? All right. Hearing none, I do have a couple of questions myself. When you talk about co-branded shirts, are we talking about a shirt that would have the Ameren UE logo or patch, as well as the, like in this case, Anton's company logo as well?
It may say Anton's, or it may say a contractor working on behalf of the program. I'll give you an example. Let me refer to, because I want to read specifically what it says. The badge. It indicates that it indicates the implementation contractor. Give me just a second. For instance, the contractor badge will say approved contractor for the Ameren, Missouri Residential Energy Efficiency Program. And it says verified by Franklin Energy, which is the administrator for the program.
And that's on the shirt or on the badge?
That's on the badge.
Okay. In your rebuttal testimony, page 16, lines 3 to 5 roughly. You're saying if there are any Ameren, Missouri branded shirts, they should be co-branded with Anton's logo or the Community Savers Program logo. So if that shirt had the Community Savers logo on it, what else would be on that shirt?
It should be co-branded with a qualified contractor by Franklin Energy or something like that
On the shirt?
on the shirt.
Okay.
These were guidelines that were put out from our marketing team, and the intent was to make sure that the logo was accurate. This shirt co-branding, it didn't follow the guidelines. I looked into that, but again, the most important part is that badge. I think about it like Amazon. Whenever they pull up to your house in an Amazon truck or an Amazon box, you trust that. It's same with the Ameren, Missouri program and logo. We just want to make sure that that's not damaged.
Now, Anton's is involved in which program? Community Savers?
They're involved in the Community Savers program and the Pay As You Save program.
Okay.
And the heating and cooling program.
Are there any contractors under either of those programs that you know of that wear the co-branded shirts, Ameren's logo, their logo?
No. Typically, I'll talk about the heating and cooling program. The heating and cooling contractors want to display their logo, not Ameren, Missouri's. But the implementation contractor for the Community Savers program, and it's very, the strategy works. It's important that they have that trust with the customer to get in the customer's home, which is why they require the badges. So to answer your question, no.
In those instances where you have provided co-branded shirts, who pays for that?
The implementation contractor.
So in the Community Savers program, that'd be Resource Innovations?
That would be Resource Innovations.
Okay. I believe there was pre-filed testimony that indicated that Ameren's website at one time stated that the home energy advisor that would come to visit the home would be wearing an Ameren, Missouri shirt and would have an Ameren picture ID badge, but you're saying that's not how it actually happens. Is that correct?
That is how it happens for the Community Savers program. So they
an
wear
Ameren, Missouri shirt.
Yeah, that should have been co-branded per the guidelines.
Okay. So if that information is still on your website, that would be accurate?
It is not on our website now, and the reason why that is, it did call out Anton specifically at one point, but that's because we only had one contractor.
Okay.
in the program, in the Community Savers Program. There has since been another contractor added, so what is on the website is, look for a contractor badge, a Ameren representative wearing a contractor badge. I'll correct myself there. It did say that the Community Savers Program is fully subscribed now, so we took that part out, but it did before it was subscribed, giving customers an indication what to look for.
Okay. Those are the only questions I have. Ms. Kerr, do you have any follow-up questions?
No, thank you.
Mr. Barrett?
No, thank you.
And Mr. Lowry, do you have any redirect?
Maybe just a little, Your Honor. Just to make sure the record is clear, and I think maybe the judge can actually see this, is the contractor badge that you referred to, is that actually included in one of the schedules to your testimony?
Yes, it is.
And is that part of Schedule SRH-R3?
Yes, it is.
You referred to a heating and cooling program. Is that the same as the HVAC program that I talked about earlier this morning?
Yes, it is.
Could you explain why, in the questions I believe you, well, I know you got from Mr. Barrett and maybe some from the judge as well, there was this discussion about co-branding, and you talked about sort of a trust and security issue, making sure customers understood that these were commission-approved Ameren, Missouri energy efficiency programs. But then in one of the answers you gave to the judge, I think you suggested that that's really not an issue with the HVAC program. Can you explain why?
In the HVAC program, customers are choosing the contractors. They're choosing which contractor from a network of 400 that are in the program. So they choose them, they know which contractor they chose, and they know which contractor is coming to their home.
So Ameren, Missouri is not out there suggesting contractors to them or actually doing anything in their homes. Ameren, Missouri, all it does is if you buy the right air conditioner and it's got, say, $1,000 rebate, the contractor they chose is the one that fills all that out and makes sure that they get the rebate. Is that right?
That's correct.
Why is there 400-plus contractors in the HVAC program and only a couple in Community Savers, single family, and maybe 5 or 6 in pays? Why is that?
By virtue of the energy savings goals and the sheer volume of HVAC systems that go through the programs. So I'll give you an example. On average, from 2019, I pulled some data on the number of systems. From 2019 to 2023, there were over 14,000 installations of HVAC systems in the heating and cooling program, or the HVAC program. In the single-family income eligible program, as part of the Community Savers Program, there were less than 200, so 163 systems on average. So 1%.
So you just don't need very many contractors to handle that level of installations a year?
No, it's not a cost-effective approach to open that network up to a wide range of contractors, because it takes a lot to set up. These contractors. The implementation contractor, they not only perform HVAC services, they go in and they do assessments, they install other measures, and they have to integrate their systems with the scheduling system, so it's not cost effective to set up a lot of contractors. So it's the best strategy for our customers to deliver the energy savings goals for the program. at the budget that we have.
So one last question. If the program implementer, which is Resource Innovations, is that right?
That's correct.
If they implemented the program in a less cost-effective way, who ends up paying for that?
Customers end up paying for that. So that is important. I just want to, just to clarify, it is important to keep the costs low because it is true that ratepayers pay for this. It's not in base rates, but it is included in an energy efficiency investment charge, a separate line item on customers' bills, so all customers. So it's important to keep that cost low. And the strategy chosen by the implementation contractors works. It's a well-performing program.
Thank you, Ms. Harmon. Those are the only questions I have, Judge.
All right, thank you. Ms. Harmon, I have an kind of kind of a tangential question for you. You were here earlier when Mr. Kiesling testified, correct?
Yes.
And Mr. Kiesling used the term MIA. I should have asked him this question, but that is MEEIA, correct?
That's correct.
And can you tell, for the sake of the record, can you tell us what that stands for?
Missouri Energy Efficiency Investment Act.
All right, thank you. All right, having said that, Mr. Lowry, you disagree with that? No. You're shaking your head. Ms. Kerr, do you have any recross?
No, and I apologize for not having Mr. Kiesling explain what that acronym meant.
Mr. Barrett, do you have any recross?
None, thank you,
All
Judge.
right. So this witness may be excused. All right. Thank you for your testimony. Any further witnesses, Mr. Lowry?
No, Your Honor.
All right. Are the parties ready to present closing arguments?
I wasn't.
I
expecting
wasn't.
to, since we are planning on briefing it.
So,
I see no reason to tell
Okay.
you inartfully what I hope to write somewhat eloquently.
I also was not prepared to make a closing argument unless you
But if
like
you
it.
want,
all right, you're building this up. These better be good briefs. All right. I am told that we should receive the transcripts by July 30th. The initial briefs are due on August.
Judge, if I
Ninth.
might, in terms of the due dates of the brief, those dates were set and agreed upon before I was involved in the case.
All right.
My wife and I are going to be on vacation for 2 weeks, right around when they're due. So I've checked with counsel, and I was hoping that we could change the initial brief date to the 21st of August and the reply to the 30th, and counsel have indicated they have no objection to that.
All right. That works out nicely because I've had people tell me that I'm overly picky, and so that will give me more time to pick over the transcript and make sure it's correct. Although I rarely need to make any changes to Ms. Bench's transcripts. So, all right. So initial briefs August 21st, reply briefs August 30th.
Yes, thank you.
I'll do an order. All right. So is there anything further?
nothing from complainants.
Nothing from the company.
All right. Then I'll adjourn the hearing. We'll go off the record. Going off the record.